So family. Family is complicated, I think is one way to describe it. And leaving aside all the internal politics, the idea of family is pretty complicated. I think in 2013 in Canada, there are a lot of different answers to the question of what makes up a family. And I think family is complicated for employers as well. I think employers and employees have always really struggled to figure out the appropriate balance between workplace responsibilities and home life. And I think it's more complicated for employers because they know they have this duty to accommodate something called family status, and they don't really always know what that is. So there are two recent cases I want to talk about that have shed a little bit of light on what that might look like. The first one is called Johnstone, and it was a case in the federal sector. And the applicant in that case was a Border Services employee who worked at Pearson Airport. And Border Services runs 24/7 at Pearson. So all of the employees who worked there were required to work rotating shifts on a regular basis. And the applicant had her first child in 2003 and went on parental leave. And when she came back, she couldn't find childcare. A nanny was too expensive, she had no family nearby, and there was not a single daycare open on Saturday night. So she went to her employer and she requested fixed day shifts 3 days a week for 13 hours each day. And the reason she requested that was because it would entitle her to maintain her full-time status, and her pension and her benefits were tied to staying a full-time employee. And the employer said no. The employer had this unwritten policy that the only people who got fixed day shifts were part-time employees. So they offered the applicant part-time work, which she accepted, and then on the down low, she went and did a human rights complaint. And that gradually worked its way through the system, very, very slowly. And in 2005, she had another child, went on mat leave again, and made the same request again. The answer was still no. And finally, her human rights complaint got before the tribunal just after she came back. And the tribunal found for the applicant. The tribunal found that the ground of family status under the Canadian Human Rights Act, it incorporates a parent's child care responsibilities, and they made a pretty powerful quote, I think, that I'd like to read to you, which is that the freedom to choose to become a parent is so vital that it should not be constrained by fear of discriminatory consequences. As a society, Canada should recognize this fundamental freedom and support that choice wherever possible. For the employer, this means assessing situations such as Ms. Johnstone's on an individual basis and working together with her to create a workable solution that balances her parental obligations with her work opportunities, short of undue hardship. And in that case, the tribunal accepted the applicant's submissions that she was not able to find reasonable childcare, and that if she had been granted this schedule that she'd requested, she would have been able to balance her childcare responsibilities with her full-time employment obligations. And the tribunal also found that the employer had not done a good job of establishing undue hardship. The tribunal was particularly hard on the employer for applying its unwritten policy completely and flexibly, without sort of making an inquiry into the accommodation that the employee was requesting and whether that was possible. And like many tribunals, it was not terribly sympathetic to the respondent employer's argument that, this would open the floodgates and everybody would be off getting accommodated for childcare responsibilities. And their view was that, every employer has employees in many different stages of life, and there's no reasonable way that all of them are going to have caregiving responsibilities at the same time. And so Border Services appealed this decision to the federal court, and the federal court said that the tribunal had been right. And significantly, throughout the process, Border Services had relied on a 2004 case from the British Columbia Court of Appeal that had held that the appropriate test to apply in a family status discrimination case was whether the employment rule creates a serious interference with a substantial parental or other familial duty. And the tribunal and the federal court subsequently found that that was too high a standard and that was too much to require an applicant to establish. And they found that the appropriate test was whether the employment rule interferes with an employee's ability to fulfill her substantial parental obligations in a realistic way. The substantial interference test from the British Columbia Court of Appeal was also recently rejected by the Ontario Human Rights Tribunal. And in that case, the issue wasn't childcare, it was parent care. The applicant in that case had been employed as an architect at the same firm since 1982, and he sort of slowly worked his way up, and in 2005 was put in charge of building the Trump Tower downtown. This is a big project for the company, and they were very concerned about it. At the exact same time, the applicant was the primary caregiver for his ailing mother, who had osteoporosis and was virtually incapable of caring for herself, had very limited mobility. And he tried to put her on a waiting list for a long-term care home, but was waiting and had only been able to get part-time home care. So from the middle of 2007 until the middle of 2008, he had 116 absence days or partial absence days. And his position was that on all of those days he was working from home or he was reachable by phone, and so that this was totally sufficient. His employer, perhaps understandably, became a bit frustrated by this level of absence and was concerned about this very important project. And so their response was to write him a series of warning letters, sort of increasingly strident about the requirement that he be in the office from 9 until 5 every single day. And of course, the applicant didn't do that, and he was ultimately terminated. And he filed a human rights complaint. So the tribunal held, in this case, that in order to prove discrimination on the basis of family status under the Human Rights Code of Ontario, an applicant has to establish that he or she has been adversely affected by the employer's policy as a result of caregiving obligations. And what the tribunal held there that I think is important is they said, what's protected by human rights legislation is not the employee's preference or choice with respect to giving care, it's their obligation, and what the employee has to establish is an obligation. So, like the Johnstone case, it was found that the employer didn't sort of look properly into what it could have done to accommodate the applicant, and that specifically their procedural duty of accommodation required them, once they were aware that the applicant had any kind of caregiving responsibilities, to look into those requirements, to make the appropriate inquiries and to determine whether or not it had a duty to accommodate. The employer didn't do that, and the employer also didn't do a good job of establishing why exactly it would be undue hardship to have the applicant out of the office on a certain number of days if he was in fact available by phone. So, what do these cases tell employers? I think the test that's going to be applied in cases of family status discrimination is probably a little bit unclear until an appellate court has a chance to weigh in on this issue, at least in Ontario. But I think there are valuable things that can be taken from these cases. First, I think the good news for employers is that it's very clear that you don't have an obligation to accommodate every single request that relates to family responsibilities, whether they're childcare or elder care. And I think this is an important thing to bear in mind, given that we have an aging population, the idea of Canadian family is changing, and I think employers are A, going to get a lot more of these requests, but B, they're going to get them in circumstances that are a little bit complicated. I mean, family's a complicated issue. So, I think employers are entitled to ask employees to advise whether they've made inquiries into other ways that they can meet their family obligations and not just sort of take them at their word. However, I think these cases, provide a couple of lessons to employers that are important to keep in mind no matter what the ground of for the accommodation that's being requested. First, the procedural duty to accommodate is just as important as the substantive duty. It's important as soon as you become aware of an employee's obligations or a need for some kind of support that you make the appropriate inquiries and you determine whether or not you have a duty to accommodate those needs. I think the second piece is that both of these cases, the decision makers were particularly hard on the employer, formalistically relying on policies or its views on how things needed to work without being able to justify them and why they amounted to undue hardship. So I think employers need to be cautious when establishing policies to make sure that they're based on demonstrable operational requirements and that these policies need to be applied flexibly. So thanks very much.